Hello and welcome to The Wire. I am here to talk to Mr. Fali Nariman, who is undoubtedly one of India's great minds. This is for a book by Pritish Nandi, where he will be talking to some great minds. This is an interview that he has requested me to do. Sir, I'm going to ask you things that I think many people in this country are interested in. I crowdsourced some of these questions. But also just things that I, as a much younger lawyer, am interested in. How do you approach a case? There was something that you said to me years ago. You said, stop reading and step back and think about it.
This is what our Attorney General Daftari once told me. That's how I got it. He said, Fali, it's all right reading your brief, but I always keep it aside, and then when you go for a walk or you think at night about it, somehow there is that facility in the brain, everybody's brain, which sort of gets activated if you think about something hard, and then you leave it, and then it comes back to you, and suddenly you think that, oh my God, I never thought of this. And hasn't it occurred to you? Yeah. It has occurred to me very often. I never thought of this. In fact, after a case, sometimes I regret having said something which I should not have said. Yeah, so it all depends. I mean, but thinking about a case is far more important than reading it itself. Reading it by itself is nothing. It's just accumulated knowledge. But this is, you mix it up with everything that is in your mind, which hopefully is a mind which has read and yes, which has flourished on various things that has occurred in your life, and that helps a great deal to my mind. I mean, I found that the best advice I ever received.
How do you approach a case? And actually it would be interesting to see, since you were a very young lawyer, when you joined the profession to now, how has the way in which you approach a case changed?
Oh, totally changed, yeah. When you are first a lawyer, you first and foremost don't know whether you are saying something correctly, whether the judge will be annoyed with you, whether he'll throw some papers at you, because we used to have judges in Bombay who used to throw papers at us if something was stitched wrongly or something went wrong with the presentation as opposed to what was already on paper. But of course, many of the judges were good to young people. That's how we thrived. I mean, that's how we thrived. But it totally changes, because I think the law as a profession, in fact, instills in one a constant learning. It's a constant learning. My senior, Sir Jamsetji Kanga, when he was 92, he died in 94, kept telling us, and genuinely, we would hear something and he would say, I'm still learning. And if somebody asked him about the Constitution, he knew nothing, because after 1950, virtually he had retired. It was before that particular time, right from the 1900 to 1950, that he tried, and there was no case that he didn't know about, virtually.
Right.
But he was such a humble person that if anybody came and asked him about something about the Constitution, he said, I know nothing. You go and ask all these juniors of mine who would be sitting around.
Right.
Yeah, don't ask me. So that's the sort of man he was. But we learned from him. We learned means we imbibed all that stuff, which you can't do without. You have a great man, and
yes,
you feel that you have imbibed something from him. Tremendous.
And that's something that you have said before also, that that you must keep learning. You also said, and this is something that strengthened my belief in it.
Yeah.
Don't specialize.
Yeah, absolutely. Oh, absolutely. I think that you go down the slope when you specialize. You make more money, of course. All these chaps who suddenly say that I'm only a specialist in tax. Because I remember Justice Ramaswamy, not the one who was impeached, the other Ramaswamy, right, the older man, a very good man, very nice person, from Patna. He was Chief Justice. He once told me, he said that you can only be a good tax lawyer, and he was a very good tax judge, actually, if you know civil law, if you know the rest of civil law. And how do you know the rest of civil law? Unless you have practiced and you have familiarized yourself with that rest of branch. Because if you suddenly at a very early stage branch off into a specialization, and then you are left high and dry. And that's why a civil lawyer can, if pressed, do a criminal case, whereas the opposite is not necessarily so. That I found that quite frequently. You say he's a criminal lawyer. Not that he's a criminal lawyer. You see a lawyer practicing criminal law. And that man is very unlikely to get into the civil side. Whereas we very often put a foot there and argue something in bail or some important matter or something or the other and acquaint ourselves with criminal law. It's not very difficult, but the converse is not always true. Civil law is a very, very tough business.
And of course, you have so effectively, you did Jayalalitha, you did the Shankaracharya case, you did, so you've done a number of criminal cases incredibly effectively.
That's true. That's all a matter of training. You see, once you know something, once you know law, you can do various branches of it. But you have to have a sound background to law, and that's why I find that our younger people are very good. Some of them are extraordinarily good. If you go to the colleges, which I do go and lecture, they are better than their professors. Most of them. But because they get all their dope from technology, which we never had that advantage of technology when we were young. But that's why I think that.
I like the word, you use the word dope.
Yeah.
That's a very dope thing to do. It's very cool.
Yeah, cool. No, but I personally think that, you see, your grounding in the three codes, as it were, the Civil Procedure Code, the Criminal Procedure Code and Evidence Act, they are the basic to every lawyer. And I find today, you see that everybody gets into the writ mode. You want to file a writ, writ lagao, you see, get a stay, that's finished, and then for years together nothing happens. Now that's not much good. Why? For the lawyer himself. It's okay for the client, he wants to have a writ, etc. But you see, you lose the art of drafting a plaint. A plaint is a very difficult instrument to draft. And the writ is very easy, you put anything in. There are no rules at all. You say anything in any paragraph, whatever you want to say, you say. You want to defame somebody, you defame him or her. But in a plaint, it has to be the cause of action. You have to have the parties. You have to. There's a set pattern, which unfortunately is not prescribed for a writ, and everything is today converted into a writ if it's against the state. Naturally, I don't blame people because you get effective relief. You go to the High Court, eliminate all the lower courts, etc. But that somehow lessens your equipment for being better armed with your civil law, because civil law is a very, very important subject to my mind.
I've started doing a few trials though, criminal trials.
Oh yeah, very good.
Because I felt that to just do it at the Supreme Court, High Court level, I felt
it's
that
very important.
The sort of nitty-gritty is something
my
that
granddaughter is now doing all these criminal trials, and yes, and she finds it very impressive, and I like it also.
Yes.
Because then you get a different pattern. You see, you get a different judge looking at something, he shouts something at you, put some question to you, not very favorable, etc. And you have to think on your feet. Thinking on your feet is the most essential thing in the law. But that you can't think on your feet if you don't know what to think.
Exactly.
That's the problem. Exactly. You have to have that little, that cushioning. And all that. That's why your constant reading is very, very important.
Yes.
Looking up this, looking up that, looking at this. That's why I tell all the young people, don't yap in the library. Go and sit in court. Just listen. I go and sit in court if I have nothing to do. Quite often, even now, and because you get some idea. Somebody is saying something. A judge says something. Somebody else says something. You think that's wrong or that's right, but it helps you. It all adds up. It gets into.
And then you go and read it.
But not necessarily. If it's something important, yes, you do something that you've never heard of. And there's so many things you've never heard of. It all depends. That's very important. Very important, because you learn a lot. Because if somebody important is arguing, some counsel who is reasonably
who knows what they're talking about.
You know what they're talking about. You know what the judge is talking about. You don't know anything about the case, but suddenly you find, oh my God, this rings a bell. I remember this sort of thing, like that.
Yeah.
And when we are very young, that's how we helped our seniors. We would say, "Oh, sir, have you seen this case?" And they'd say, "Oh my God, this chap's a smart fellow."
Right.
Yeah, you see, like that.
Today, there is a way in which it's not quite like the emergency in Indira Gandhi's time, when you were ASG and you had in fact resigned.
Yeah.
And taken that very important and courageous stand that a lot of the judges at the time, let's face it,
Yes,
did
yes,
not.
very courageous, very good, very good. They were excellent judges. We had excellent counsel, excellent judges. Unfortunately, our Supreme Court let us down, that's all. 9 high courts were all outstanding.
And what's wonderful is also that that H.R. Khanna's dissent has now become...
Then,
yes.
and he was not some great judge in that sense, you know. He was
Right.
not some great intellectual judge, but he had what was that moral fiber. Moral fiber is so important in life. All the other chaps, Chandrachud and Bhagwati and all that, all of them were perhaps more intellectual than he was. And we all thought, in fact, that's a very important thing that you are mentioning, because at that time, all of us, we knew that Ray was going to fix the bench, Chief Justice Ray, and it would be a favorable bench from his point of view, that means government's point of view. So we were all very concerned, and we were all young, and we went to Daftari. He had retired as Attorney General, and we told him that this is scandalous, it has to be. So he went and told Chief Justice Ray, and he said that, "I believe, Chief Justice, that you are going to constituting a bench which doesn't consist of the 5 senior most judges." He said, "Yes, but when has any counsel come and told the judge, the Chief Justice?" So quick as a flash, after he had that great art, quick as a flash he said, "But I remember." Of course he didn't remember at all, but this was what he said. "I remember that when I once told Chief Justice S.R. Das, he never took it ill." Now Ray was a sort of a chela of Chief Justice S.R. Das.
Yeah.
Sudhiranjan Das was one of the great judges of our time.
Yes.
And so he said, no, I'm not taking it ill. and then he fixed the judges, the 5 senior most, and they let us down. You see, it didn't work, except for Khanna, who was number 2.
Except for Khanna, and then, you know, some of the great dissents have also
But
now
just
started to
imagine that,
become law,
but I
which
always
is so
think about
wonderful.
this. I always think about this. That suppose Khanna also had sided with all these fellows.
Yes.
It would have been a disaster.
Yeah.
I mean, at least now we are able to say, that, "Oh, we had Khanna," you see.
Yes.
I mean, that we stand up and say, I mean, Nani Palkewala used to say that the New York Times said that there should be a statue on every corner of India for this great judge. I mean, hell of a nice thing to say, little highfalutin, but still, I mean, that's the sort of thing. And not that he was some great gun, and after retirement he simply flourished. He's a very dear person, very nice person, and a very distinguished person. I became more distinguished. You know, it becomes you. You achieve something, and then you become a little better, more important, more. And he sort of was able to go all around the world. And he was feted and honored and dined and wined.
You know, one thing, we'll come back to the emergency, but one thing I sort of found, where, you know, I was doing some international arbitrations abroad and was involved in other international law issues, that your name consistently came up as somebody that they deeply respected, and also, more interestingly, thought of as one of their own in terms of the people that they greatly respected. You know?
That's true. Because, you see, I had this occasion.
But how did you manage to do it from India?
Because I tell you, because my wife and I started going out to all these law conferences from the very beginning.
Right.
And if you take all this a little seriously, then they say that, "Oh my God, this chap from India has just come. He's come again. Now he's come again to a third. You know, every 3 years, every 4 years." Then they say, "No, now will you come on this committee? Then will you become vice president? Will you become president?" Like that. That's how we all. I mean, not that we particularly wanted to, but if we showed genuine interest, and then you improve yourself also.
Absolutely.
After all, you look around the world. Law is not all in India; it's all over the world. I mean,
absolutely.
And you learn so much from all the common law, civil law. There's so much to learn. No one can say he knows the law in that sense. No one can say that.
Absolutely. But coming back to authoritarianism, sir, there's a way in which, there's a creeping authoritarianism, I beg your pardon, now. So
there was also when Mrs. Gandhi was there.
But was it creeping or was it sudden?
Yeah, absolutely. She wanted it. They wanted to amend the constitution. She would have been made queen, not just president, queen. Yeah, I have no doubt about it. Please don't have any qualms about it. This is the problem of a majoritarian government. There's such graces for a majoritarian government. It can do so much, but somehow we are dogged with this mentality that the moment there is an authoritarian government, they want to exercise the Mughal rule, you see, Ji Hazur.
That's wonderfully put. Do you think, though, that our Supreme Court is coping better than the Supreme Court did in 1975, 1976, etc.?
I don't know. It's too early to say because this chap the Prime Minister is just finding his feet and he's now cornering the entire country. So it all depends. I'm a little skeptical now. I'm a little skeptical because you see, you mustn't blame the judges also. The judges are a product of whatever they've come about. I mean, you must remember all this is long since. This is all ancient history virtually. 1975 is, in terms of history, modern history, is almost ancient. So nobody remembers it, nobody bothers about it. I always keep reminding people of the emergence. It's very good to remind people. It's very important. Yeah. And when I said some time ago that we are now with the chief minister of a premier state of the country being a practicing priest, not that it's illegal, but that only shows that we are getting into a Hindu state. Now, I don't find any Hindu saying that. See, we saying it is no good.
No, I think we're certainly becoming that.
I'm not saying, you're saying, yeah, but listen, because a Muslim can say that, a Parsi can say that, etc. But although a lot of Parsis are very fond of the Prime Minister Modi and the way he's going and so on, and he's helped the Parsis. I mean, make no mistake. I mean, he's been extraordinarily kind to the Parsis. I have no qualms about it. But that's not the test. That's not the test because he's kind to Parsis. Therefore, I, a Parsi, should say that this is correct and that's the way to go. I don't want a Hindu state. I have not been brought up in a Hindu state. This is where I find it very difficult to. But of course, I'm not for myself. Because we are out of the woods almost. But for the younger people today, you see, our grandchildren, our children, and all, what sort of future will they have? I don't know. In a Hindu state, I don't know. You see, if it's like a theocratic state, just imagine if the roles of Jinnah and Nehru had been reversed, and Nehru had died, like Jinnah died within 6 months, India might have been different. It was that stability that he contributed for about 10 or 15 years, which was so important to my mind, because all this highfalutin rule of law, etc., that we keep talking about is all because of him only because of him, not because of anybody else.
I mean, the argument, of course, that the Sangh Parivar makes is that they say that secularism is something that was only inserted later.
Yeah, that's correct. But but it was inherent in the constitution. That's true. They say it was inherent. I don't accept it because there's a lot about religion in our constitution, and rightly, yes. because you see, people. I mean, we must realize our weaknesses also. People today, even if a Harijan goes to a well which is consecrated and which is only used by the Brahmins, they'll kill him. And even today they'd kill him in certain parts of the country. So that sort of thing we have to remember, that this is the sort of ethos in which we have all been brought up. And it's not only the cities, it's all the rural areas, everywhere, where all this goes on. So we have to be extraordinarily careful. And in administering a country like this, how do you think the British administered us with only 5,000 people, including about 1,000 soldiers?
Yeah.
And I mean, the whole huge subcontinent, including what is Bangladesh, what is Pakistan, every damn thing.
Yes.
I mean, simple. You see, yes, they did divide and rule, divide and rule, divide and rule. That's a good theory. I agree.
Yes.
But there was no other way. There was no other way. There was no other way. And they gave titles, which was remarkable. Khan Bahadur, Khan Sahib. Oh
Yes.
God, people would die for it.
Rai Bahadur.
Rai Bahadur.
The ICS.
ICS. All that
We saw a lot of that in Bengal.
Caboodle.
In terms, though, of the sort of rollback of constitutional values,
Yeah.
and you said that the high courts, and this is so true, that the high courts were...
Why? Because
the high courts had been strong.
Yeah, they were established courts. You see, that's why I have great faith in established court. Not that I don't have faith in the Supreme Court, it's now an established court. But I have no faith in tribunals. This tribunalization is something which is anathema to me.
Because?
For the simple reason that it is self-created, it has no history, none of the tribunals, it has no background, no roots. You see, an institution must have roots. The high courts have been there since 1862. Remember that. It's a tremendous, 175 years is not a small time.
Absolutely.
And therefore, that makes all the difference. And that is exactly why you found judges, odd sort of judges in odd sort of high courts, ruling in favor of the citizen, ruling in favor of... Why do you think that they were also inspired like Khanna? Khanna was not the only chap. He happened to be in the Supreme Court. But all these high court judges were outstanding. A.P. Sen, who was in Rajasthan, who later came to the Supreme Court. All their judgments were all overturned, nine of them by the Supreme Court in one blush. As I told you, was 5. Because they thought that Mrs. Gandhi will last forever. This is the problem, you see. We all think that like Hitler will go on forever, like that. So everybody thinks that all this will go on forever. But sometimes fate, delivers that wet towel, as Buddha says. Knocks you on the head.
But in terms of a bulwark, you were also in the NJAC case.
Yes, of course. We had a lot of pressure against us. Yeah.
You were in the NJAC case, but you were also in the 9 judges case after SP Gupta, etc.
That's right. We knew something about the judges case, you see, and how it came about, because that was Verma's theory actually. Verma seemed to have thought that taking the cue from how judges were being appointed and how the government was resisting everybody, the judiciary, that they devised this new formula which nobody has devised anywhere in the world, namely that the judges themselves would recommend. It's not working too well, I can assure you. It's not working well, because judges themselves are at odds with each other and so on. But giving it back to government is a disaster. That's why I told the Attorney General in court, because I argued the main case. And I said that I am willing to take Venkatachala's formula. I don't want this collegium. Have a commission, I am not bothered. But have a commission with 3 senior most judges as members of the commission, with 2 extra, whoever you want, the law minister and so on, as appointing authority. But the majority has to be 3. And that's what Chief Justice Venkatachala has said in his review of the Constitution report. Yes. And I said, take it now. I withdraw this petition. You take it now. I have no objection. And I am still, and perhaps that would have been the best thing that could have happened. But these are things, ifs of history. You can't help it.
But coming back to judges, I mean, it's very, for women who grow up in the profession and who grow up believing, expecting a certain amount of equality, expecting to have the same number of role models, expecting judges to be equally divided. The situation in the Supreme Court, some of the high courts have improved, but the situation in the Supreme Court has not improved at all. In fact,
right.
In fact, it's gotten worse, because now you have more judges, but you still have that token single woman judge. And but not just in terms of gender.
Thapar, I remember Karan Thapar interviewing a former Chief Justice, and he said, "But sir, what about women as judges?"
Yes.
He said, "Oh, but England didn't have it for 100 years. So he says, are you now proposing that we don't have it for another 100 years? And that poor chap looked such a fool, the Chief Justice concerned. He was a sitting Chief Justice.
Right.
Ridiculous.
So, a bit of a mistake sometimes, I think, to give interviews
that
when
sort
you're a
of thing.
sitting
You are not
Chief
used to, you
Justice.
see, this sort of back chat. Right. So then you say something very stupid and you regret it.
You know, Justice Scalia started speaking about the devil. He was on the Supreme Court. I'll send you that interview.
Who?
And Justice Scalia of the US Supreme Court.
Yes.
And he was talking about the devil like it was a real thing, you know, which is very worrying because the gentleman was still deciding cases. No, but in terms of, so perhaps that is in part a product of the collegium system.
Yes,
you know,
it's not working well. It's not working well. I write again, because you see, all 5 members don't think the same. One chap sulks and sits in his chamber and says, I won't come to the meeting. I have written about it, but it's all useless. It's all hopeless. I don't know. These people have no idea about how a judiciary, an institution has to function. You have to live and let live. You have to give a little, take a little, like that. You can't have everything that I want. Yeah. And people have to respect you. You see, this is what I find. Unfortunately, we've had this phenomenon of, you see, the last person that whom I can recall, who was a Chief Justice, whom the judges themselves looked up to, whom the bar looked up to, was Venkatachala. There was nobody else. After him, there was
do you mean intellectually or do you also mean in other
no,
ways?
Intellectually and in integrity. You see, we knew that
Justice
he was...
Verma had a lot of integrity.
But Verma would get annoyed, you see, with the counsel, etc. He had that habit. Whereas Venkatachala was remarkable. I had seen him once in court, sitting, and that advocate shouted at him. So he shouted back, just like that, on the spur of the moment. He never shouted. He just shouted. Then he said, no, Mr. So-and-so, today is not the day for hearing your matter. We'll hear it next week. Just like that. Yeah. See that breeding, you see, that sort of...
So privileging the institution over your own sporadic feeling and emotion.
I'm sitting. I don't have to stoop to this fellow's level.
And I am the court. I am not a human.
Yeah.
You know,
I am the last
an individual
word,
person.
Yes.
Yeah.
Virtually, it's off with your head. I mean, there's no question.
Exactly.
The judge sits there. He's absolutely the supremo.
Yes.
But you must realize the restraint on power.
Yes. Well, coming back to the composition of the benches, you know, we had in the triple talaq case, in the Shaira Bano case, there was an acknowledgement that diversity is something that's required.
I agree.
So you had
but that
judges
depends
from
again
various
on the
religions.
Chief Justice. You see, the Chief Justice picks the bench. You
Absolutely.
must remember that.
So you had
It's
judges from various.
yeah.
No, but they did have judges from various religions.
Yes, he was very keen. Yeah.
He was very keen. However, it was exclusively male.
Yeah, that's right. Quite.
And exclusively male, and also in terms of the composition, it tends to be predominantly upper caste. It tends to be predominantly, in fact, Brahmin.
Yeah.
It tends to be predominantly Hindu.
Yeah.
And it tends to be almost completely male.
Yeah.
You know, and with not a
this
gay
male
person inside.
chauvinism is in Indian society.
But how do we start to deal with this? Because there's lots of data that shows that development in and of itself is not something that ever succeeds in dealing with gender equality. So in terms of the law, and here specifically the judiciary, let us specifically speak of the Supreme Court or even the High Courts, but let's talk about the Supreme Court. Supreme Court is behind the High Courts here. What do you think is the best way? Because when Ruma Pal was on the bench, for instance, there was a way in which the way we were treated as counsel was, there was a boost for women counsel.
Yeah, absolutely.
Because there was some kind of belief that, women can do this and women can do this brilliantly.
Yeah.
So how do you think this can be changed? Do you think we should have reservation?
No, I don't think so. But it has to be a realization with the Chief Justice. Chief Justice has to move. That's why he's Chief Justice. That's why perhaps it shouldn't go by seniority only, perhaps. But then if you don't go by seniority, then you say government appointed him, that fellow wanted it, third chap wanted it, fourth fellow wanted it. Yeah. And as yearning for the Chief Justiceship, like Ray got it. He was number 4, he would never have become Chief Justice, but for the fact that he superseded 3. So these things are very difficult to tell in India. In India, I don't know what is the best system. I'm not very sure. But I think it must be the upbringing of the the gentleman who is the CJI himself, because he is able to influence his collegium, or we presume so. I mean, that's how you should have enough personality to be able to influence his collegium. After all, the Chief Justice is the Chief Justice of the court and the Chief Justice of India. And a Chief Justice does command, if not respect, at least fear, because they worried, because judges then begin to feel that, oh my God, he may suddenly push me off onto some odd assignment which has no relevance at all to anything. Absolutely. So it has to work that way. But unfortunately, we don't have a term for the Chief Justice. All the Chief Justices have been for one year, 1.5 years, 2 years. And when it was 4 or 5 years, they did very little. They did nothing for themselves. This is a problem.
Do you think one way, maybe, before we leave the gender on the Supreme Court issue, I mean, do you think maybe one way is that if they set aspirational quotas for themselves, if they said that we must have 50% of the bench be female, and then if you have that aspirational quota, then you start reaching out to the high courts.
Provided it's aspirational. You see, it's not compulsory. It's aspirational, because you may not have somebody competent enough. You see, you can't just appoint somebody just because he happens to be because of
there are all these wonderful women in the high courts.
They're wonderful. I have no doubt. I'm just telling you. That's very good. Correct. And you must. There's no doubt. And they improve. I mean, judges.
Once they're there, they also
once
improve.
they improve. I mean, that's at least the expectation.
Yes.
Some don't, of course.
Don't.
But then that's a human being. So we are all like that. Males are as bad, or perhaps a little worse.
And so let everyone have the privilege of being equally.
Therefore it has to be
equal opportunity in mediocrity and in brilliance.
Yeah, of course. Right. This is merit and all is a bit, misplaced, quite frankly. I'm not a great fellow for only merit and great, because how do you know that you are meritorious and I'm not, or I'm meritorious and you are not?
I've certainly had a lot of privilege. Yeah. And when you were speaking of H.R. Khanna, for instance, and you were saying he was not the most brilliant, but he was the most courageous.
Yeah, that's right. You know? Courageous, integrity, everything.
Absolutely.
Yeah. And broad-based, you see, liberal. What's the use of a constitution without a liberal judge, by and large?
Right. Very much under attack these days, that very idea of liberalism. Now, coming to freedom of expression, sir. Now, we are at a time when there is, do you believe that there's a rollback of freedom of expression and those rights?
Yeah, temporarily, I suppose, yeah. But then you see, because it all depends. It's that mentality, what L.K. Advani told them, all the journalists after the emergency, that we asked you to bend and why did you all crawl, you see.
Yes.
I mean, that's the sort of thing that happen.
Yes.
And in India, they do crawl, you see. We've had this Mughal Raj, the British rule, Sir, Your Excellency, like that, Ji Hazur, all these Mughal rule. So we've had that there is a hierarchy, and you must respect your elders. So that you must respect the people who rule over you. Yeah. That respect, you see, is now dwindling. We don't have respect for your ruler. Just because a person is in government, we don't have respect. But then you see, our acts are
unless he forces you to have respect.
Yeah, but you see, the law of sedition has interpreted. You must remember, the law of sedition as interpreted in Southeast Asia is entirely different from the law of sedition as interpreted in India.
Yes. Yes.
Because they follow the Privy Council judgment, which means you have to have affection for your government. It says affection. The section says affection.
Yes.
I mean, who has affection for his government? Nobody has affection.
Right.
But you have to have affection. So they look upon it in that sense. They said nothing of the kind. All this is all right, but it means sedition only is, you can invoke that provision only when there's a disturbance of law and order. That's like that.
Or tendency to.
Or the tendency, yeah.
But that therein lies the great exploitation of the ruler.
So all this sedition is very badly phrased. It was a British product. But fortunately for India, the Supreme Court followed the Federal Court in preference to the Privy Council. That was a great thing.
Were they not wrong? Were they not wrong, the Supreme Court, in merely reading it down and rather than striking it down?
That's one way of putting it. But there again, you find they wanted to include it, they excluded it, they were not quite sure whether to include it in the in the 1902, and there was a lot of debate on that. So, but the way it was interpreted by Chief Justice Sinha was perhaps the best interpretation we could have given, because he followed the federal court, Sir Maurice Guire's judgment, which said that no, it has to be something which is accompanied by an immediate threat to law and order, or an actual law and order threat. That's all. Not, you can say anything you like about your government. You don't have to have affection for it. The word used is affection in 124.
Disaffection. One thing that troubles me though is that, when you have all these Supreme Court judgments, whether it's Ramji Lal Modi, whether it's K. Har Singh, whether it's, reading down IPC provisions, and the trouble is that many of these speech offences are cognizable.
Yes.
And you have your average constable is not going to know about that constitutional bench judgment, and those words are not read, are not in the IPC that is before the constable.
Quite right. Quite right. Sedition is the worst there. You see, nobody knows that sedition. Who says that law and order is involved? You read the section. Says nothing of the kind. I'll just put you in. Because
like when you see 295A, something that we deal with a lot these days.
Yes, it's the same thing.
And something some of my clients have dealt with.
Exactly.
They have no idea about
and
the judgment.
this law is administered by people who are not expected to know anything about it.
So what's the solution to that? Could we perhaps include the words in the provision itself in future publications?
I think so. Much better. Quite right. It must be prominent. Must be prominent. Particularly if it's a Supreme Court dictum.
Yes.
That has to be put in right at the start.
Into the legislation?
Into the legislation, or at least as an appendage to it, or whatever it is. But it has to be official. That's another problem.
We had discussed criminal defamation on a panel in which you very eloquently and memorably said that criminal defamation as a law is something that must be struck down.
Yeah, that's correct. Should have. On your principle, that reasonable restriction.
On the reasonable restriction. Unfortunately, it has not.
It has not. Now, that's impossible now to get. You can't get it.
But do you then believe it should go to a 5-judge bench? Now, we have most things going to a 5-judge bench. A lot of important constitutional issues, as the constitution itself says.
Yes, I suppose it grows. Yes, everything grows. You get more. You see things as you never saw them before. You see new things which you remember against old things, like that. Yeah, it's possible. It's possible because it's being misused. There's no doubt about it. This criminal defamation is really not meant to be used at all. It's now abolished in England long since.
Yes.
Yeah. And civil defamation, nobody gives you any damages worth of asking.
Yes.
I mean, you can ask for 1 crore or 5 crores or 10 crores, but I mean, courts are not going to give you that amount. Very rarely.
Although what started happening, of course, is that you have large corporations that have started bringing massive cases for massive damages. But there are small but very significant developments in jurisprudence regarding strategic lawsuits against public participation.
Yes.
That now say that either the plaintiff has to disclose it, the damage, on the face of it. But that also, if a journalist, so for example, NSE versus Money Life, that Gautam Patel judgment. Have you seen it, sir?
Yes, very good.
Fantastic judgment.
Very good,
Where he gave an interim order of
nice
50 lakhs against the NSE because he said, well, they asked you. And they gave you a reasonable opportunity to respond. And now you can't come after the fact and, sue them for, crores of rupees. You've done so much work for free speech and such important work for free speech.
It's good we have judges like Gautam, you see. It's very good. Yeah, you can handpick, you can pick up people and have your own court, your own highest court, at least, and be pleased with yourself.
So we play, there's this game called fantasy football where people pick their own players. We could have our own Supreme Court.
I'll pick this.
So in the context of your long history of standing up for free speech though, there was also Devidas Tulsapurkar.
What is that?
Where that was that case where I think you were amicus.
Yes.
And you had said,
that Gandhi thing.
Yes, that
Oh
Gandhi
my
thing.
God, yeah. Oh Lord, yeah, that was again before Deepak Mishra. Yeah, correct, yes, correct.
But where you had you not supported the proposition that historical personalities should be
I think
have a higher level of protection, in the
I don't know whether higher level, but you see, I mean, Gandhi has a certain standing. That's a sort of a saintly thing, sort of. I don't think it can be used as a precedent at all. That's not a precedent. I mean,
it is a precedent now,
yeah,
sir.
no,
I mean,
but
unfortunately.
Kanju went and said that he was a British spy and so on. That's another sort of. See, these things are just not said. And Parliament then ticked him off and said that it is disgraceful, you should never have said that. I mean,
And I was in court when you were in that case, and that day I learned something.
I see.
That day I learned something, because I think that very gently and very carefully, this was my interpretation of what you were doing, very gently and very carefully,
it was a very
you seem to be
tricky
saying,
thing.
not in this matter.
Yeah, that's it, that's all. That's the correct thing. They say, otherwise, certainly, he was entitled to say anything he liked. The most foul language can be used, and it was used. And then the judge said, no, it is not to be used, not to be used. Take it out, take it out.
But the trouble with free speech is this, is that you constantly have to stand up for the kind of speech that is usually tasteless, usually, sometimes odious,
totally odious,
but that is the kind of speech that tests the boundaries, and if we don't stand up for that,
that's the test of your civilization, you must remember that. That's the test where we fail, we can't say it here because people get offended as if we are uncivilized barbarians, but we are in a way. We have to be more civilized.
But then,
must accept.
Giving you a bit of a hard time, but I will take the liberty because you had said in your book, and you've always also been like that, a bit like my father actually, that don't write sort of hagiographies about me. Don't flatter the king kind of thing. Just ask me the tough questions you like, right? In Tulsapurkar, as a Micus, he may be a saint and all that, but then are we not setting a very problematic precedent? Right?
I suppose it should be said like that.
I mean, should we not be able to say things about Gandhi, about Mahatma Gandhi, however great he was? For example, there were...
That he ill-treated his wife.
No, not just that he ill-treated his wife. There were these two young women that he used to spend sort of, it's like questionable sort of quality of time with. That the way in which, if you look at the conversations between Gandhi and Ambedkar, for example, in the annihilation of caste, I mean, to me it became so clear that the sort of the sharp clarity of Ambedkar's mind versus the preservation of caste in terms of even calling people Harijans. I mean, it's very patronizing. It's like Divyang. It's such a patronizing word, seemed to me something that was...
I'm not calling you a child of God.
I'm calling you a child of God,
And then kicking you. And then kicking you.
It's like kicking you. When, you're being killed, as you quite rightly said, when you're being sort of killed and attacked for wearing a bride shirt or for going, and drinking some water. So, in such a situation, when the principles of a nation have been founded by minds like that, is it in fact not vital that one be able to, yes, of course, intellectually disagree, like we're having a discussion
you are
now.
entitled to it.
But should you not be able to then say other things as well?
What's your criticism of the 377 judgment? Same. You see, the 377 judgment by the Supreme Court. I'm just telling you, but look at it. Absurd. All that it said was that in the privacy of your own home, you can do damn well what you like. Nobody is going to bother. With consent. Beg your pardon?
With consent.
Yes, of course with consent. Only with consent.
No, because of course in the marital rape case
that's right.
that I'm currently arguing, what the other side is saying is that I should be able to do whatever I like in the privacy of my own home.
No, correct. You're quite right. You can't assume that there is consent once you get marriage. Wow, finished. You are my tutelage, slave. Slave. That's the old theory, you see. All these chaps really think so. You have to be very careful.
They absolutely believe that.
Sickening.
Now, coming to the other side of free speech, I mean, I think that, in the United States, for instance, it's almost a religion. And they did not wish to, I mean, even speaking of hate speech would a little bit raise shackles. So the culture was such even till a couple of years ago, just before Trump. And now I think people are starting to realize. One thing that concerns at the moment, I think, here is, of course, you have these hate speech provisions like 295A and 153A that are definitely hugely overbroad. And they are being used against minorities in very problematic ways. And at the same time, and used against people who have less power. Governments down the ages have consistently done that. However, at the same time, we do have the kinds of speech that are flourishing that also flourished in Rwanda. And there are ICTR decisions, the International Criminal Tribunal of Rwanda, where they recognize this and where they talk about Radio Rwanda and they talk about the kind of diminishing human beings to the level of, calling them cockroaches, for example, so that then it's easier to wipe them out.
And look at the Rohingyas, poor chaps.
Look at the Rohingyas.
And look at that woman who got a Nobel Peace Prize. I'm so ashamed of her.
Absolutely.
Absurd. My father knew your father.
Yes.
Aung San. Horrible. But that's. I don't know what happens to people. I don't know what her. She has never come out and said what pressure on her is, or she's never seemed to suggest any pressure. There doesn't seem to be any pressure on her. The way she moves around and receives all the state guests and so on, there's no pressure at all. It's all humbug. She wants to cling to power, that's all.
In terms of the speech though, sir, if you look at some of our news channels, and if you look at, some of the very incendiary sort of speech that we have against minorities and the way in which people are starting to think. If you look at the killing, for example, of Pehlu Khan, and then you look now, then later, a man goes and on camera shoots, with an axe.
Chops him off.
Chops somebody's. And so therefore, like, in terms of speech and in terms of like an ideal world, in terms of the proximity to the violence, do you have any thoughts about in what way? I mean, of course, this is, I'm putting you in a spot a bit, so you may not have immediate thoughts.
No, but this is something.
How should it be limited?
But this is where civilization comes in.
Should it be limited?
Civilization comes in. You see, once you get outside the barrier of a civilized human being, then I'm afraid that, or a civilized state, I mean, then there's just nothing can help you. So that civilization does mean a great deal. In fact, it's very, very important. That's why Will Durant's Story of Civilization is one of the best written volumes. If you can just browse through them, they're great fun. They are written very simply and very nicely, and a lot of annotation and all that, but they are beautifully written. And that whole thing is about civilization, nothing else. To my mind, the human beings are not civilized. They have to strive to be civilized. You see, because why does an animal kill another?
But doesn't the law have a constitutive effect in terms of civilization, in terms of making us?
I'm afraid law there doesn't help.
A dialectical relationship between the law and the citizen?
No, law doesn't help. I'm afraid law doesn't help. It's your ethos, your upbringing, your education, call it civic sense, whatever it is, but law doesn't help, I'm afraid. Because we are. I mean, look at the way the Nazis behaved. I mean, how can you obliterate a whole people? I mean, it's ridiculous. But I mean, it was done. In our lifetime, it's been done. I mean, they have pictures of them being taken to camps and all that and just put away.
But the judiciary is standing still to some extent between that and...
Yeah, I agree, but what can the judiciary also do? I mean, that's why, in fact, they had a whole new set of judges in the new Germany. They cashiered a lot of these old fellows. These are events that do shake us up, but that shows how easily we can fall to these levels and not rise.
Yeah.
Rising is very difficult. Falling is very easy.
Did you read the op-ed I wrote saying the eminent jurist Fali Nariman on Bhopal?
No,
Right.
I didn't know. No, I didn't. Very good.
So I'm leading the Bhopal cases for the survivors. They've issued notice in the curative petition. You have expressed regret.
Yeah, that's in my book. It's there.
In your book, it's there. You have expressed regret.
Yeah, that's right.
In representing that case.
I wouldn't have done it if it was. You see, I thought that I was a young chap, I was doing very well, and I thought I'd do better like that. But we were all wrong. But I mean, I learned the hard way, but very bad. I agree.
But why were you wrong?
I was wrong because it can't be done. It can't be with 3,000 people dying and so on. You can't accept it. That toward a foreign power. I mean, it shocks me today, but I mean, that's no good saying all that. It's only just an excuse, you'd say. I mean, that's okay.
No, I mean, I think nobody is perfect. I mean, this is the point, right?
Therefore, that's a matter of grave regret. There's no doubt about it. I mean, there's just no doubt about it.
But is it because the settlement was too low?
No, not settlement. I don't think it had anything to do with settlement. It could have been settlement because I also, it would be the same thing. What difference does it make? I mean, does money pay for this? That doesn't. No, there's no question of settlement and no settlement.
But do you not believe
I don't, because the settlement was done by the Attorney General for the Union of India. Parasaran raised the figure from 500 to 530.
Yes.
Our chaps were not willing to give more than 500 or something. And it was 530, if I remember right.
470 something.
470, I'm sorry. Yes, and it was between those figures. Then it came down to 470. But anyway, it was miserable, there's nothing. But the problem is, how was it distributed?
No, but if the figure is such a paltry sum anyway, and the numbers...
No, the numbers, you see, that was
the number of people who died was 20,000.
No, but it was given to all sorts of people. You see, one of the advocates, our advocate, who was from Bhopal, he petitioned and he was given 500 rupees a month.
He was given 500
He was perfectly all right. Yeah, there was nothing wrong with him. He used to appear. He was with us.
But of course, the problem we're finding at the moment that we're putting before the court is that A, it was a paltry sum anyway. B, the numbers were 20,000.
Yeah, but the judgment says that the government has to give it. It's only Ahmadi who said no.
Although now...
The judgment says it, government has to give it.
The basis on which we have come in curative is twofold. One is that we're saying that there was a fraud upon the court.
Yeah.
Because Union Carbide we filed documents to demonstrate that they knew that MIC never leaves the body.
Yeah.
That there is the vast amount of damage is
correct.
Permanent damage. And there was a top secret document that between the Attorney General Parasaran at the time and the Union Carbide officials that a couple of months after the disaster, which proposed a settlement which formed the basis of the actual settlement years later. Without any consultation of anyone, etc. So these are documents that are now coming. So we are saying that there was a fraud on the court, and therefore the settlement should have been reopened. And Justice Kapadia, Constitutional Bench, they issued notice, and now they're reopening it.
Yeah.
So hopefully there will be some justice there. Let us see.
Yeah, good.
Let us see.
No, I'm done. Good.
Your family had to flee Rangoon.
We were during the war, because that is. My father was in the governor's executive council, and the governor said, "Oh yeah, Sam, you can go up to Mandalay, no problem. Like hell, no problem." The road was cut, you see, by the Japanese, so that we couldn't come back to Rangoon and go take a ship. In those days, a lot of people left by ship, but we had to come overland.
So you had to walk?
Walk, and by dolly, and by boat, and all sorts of modes of transport, and horseback, all sorts of.
And was it traumatic?
Yeah, quite traumatic. But in recollection, good fun of it. It was 21 days, but I was only 12, but I remember everything. Yeah, very remarkable. A lot of people went.
And so it gives you that empathy with others who have suffered in the same way.
It gives you that basic thing. And also you leave possession. Possessions mean very little to me. If anybody breaks a dish and all that, I don't give a damn. Although everybody else does. My mother did, my wife does. Nobody, I don't give a damn.
Sir, to wrap up, I'm going to ask you, what is the advice that you would give in these incredibly difficult and very important times, not only to lawyers, but also to judges?
Stand up and be counted, that's all. Stand up and be counted, and do the right thing. Not only law, do the right thing. Not only justice, do the right thing.
But what is the right thing?
That's right. You have to have that instinct to do the right thing. It's instinctive. This is right, this is wrong. You must have, when you are That's maturity. I mean,
Yes.
that's why
As you
your
do.
age of majority is that, and you have to do the right thing. That's the object of it. That's why you are a major and not a minor. You have to do the right thing and not the wrong thing. So you must know between right and wrong. That's one of the most essential elements in a human being. You must know the difference between right and wrong. Yes, I am doing the wrong thing. Then you must know that, yes, I am doing the wrong thing.
And if you do the right thing, then maybe like H.R. Khanna, years later you will be able to hold your head up
Yes,
high.
that's right. That's right.
Right.
That's right. Okay.
Thank
Thanks.
you, sir.
No, okay. Lovely talking to you.
Lovely talking to you.